She's not here. I guess if you want me to. Yeah. Hmm. Oh, okay. More notables.
You said.
Still, yeah, still do that.
There he is. This is up here, up front and center, Mr. Bass. Yes, sir. Doing all right, Bass.
Good to see you.
How are you, sir? Doing all right?
Oh, my God, sorry.
How are you? I'm David Barber, Zandt newspapers. Thank you.
You have a comment?
Yes, sir.
Sorry.
Y'all would please silence your phones. We'll call this meeting to order at 9:01 a.m. on Wednesday, June the 26th. And call this meeting to order. We do have a quorum. Commissioner Barton is at a conference. He won't be joining us today. So general announcements. Are there any general announcements? Is there any public comments? No public comments. Okay. I'll go to item number 4, public hearing to discuss and consider the adoption of subdivision regulations in unincorporated areas in Van Zandt County, Texas, and to receive public comment on said proposed actions pursuant to 232 of the Texas Local Government Code and 2007 of the Texas Government Code. So we will now go into our public hearing. And yeah. So is there any public comments? Concerning the new subdivision guidelines that have been proposed? Mr. Bass, can you just give us an overall summary of what the changes are in this from the ones we passed in 2021?
Yes, sir. First of all, I'd like to take a point of personal privilege and express my condolences to you all for the loss of Virgil Melton. He was a good man, worked with him closely for years. And it was very sad news that I heard here. I want you to know I appreciated his service a great deal.
Thank you.
The subdivision regulations have gone through an extensive vetting process. They have been reviewed several times, reworked several times. at the direction of Mr. Melton, the other members of the court, and the Citizens Committee appointed to serve in this capacity to review and recommend changes to the subdivision regulations. The primary changes in the regulations have to do with the legislature's recent, I say recent, passed the last legislative session, that you took away some of our regulatory authority. And that, I'll go into that in a little more detail, but the bulk of the subdivision regulations have been reviewed and refined, and I think they're in pretty good shape. On the changes that were made, and I can't explain to you the rationale for the legislature's conduct. I really don't see what advantage it brings to anyone. But they have altered the definitions of what is subject to regulation and what is not. Generally speaking, anytime you divide a tract of land into one or more parts, that and you lay out streets intended for public use, you still have to have a subdivision regulation to address those needs. However, where you do not lay out streets, you do not dedicate those streets to public use. And particularly if your lots are over 10 acres, then according to the regulation, that is not subject to regulation. I anticipate litigation will follow from that decision, simply because there are some subdividers that will open up and will develop 10+ acres of land per lot and build substandard streets that are not dedicated to public use. And in 5 to 10 years, the people that live in that subdivision will realize that their developer has gone and they have substandard roads, and they'll come look into the county to pick those roads up. That's been the practice in other circumstances. And it has been a matter of considerable grief on the part of the court. But that being the case, the legislature has spoken. So if you look at 1.3 of these regulations, that is the general exceptions to the regulations. You do also have a second tier of regulation that is designed to address those that are dividing directly on a county road or a state highway, a public road that's under public maintenance, that have only a driveway that does not serve any other lot but that lot, and they meet all the other requirements for culverts and so forth. They would be able to get that subdivision developed without going through the extensive requirements of the subdivision regulation. They would need still to provide drainage plans. They would need to make sure that their activities on that lot do not affect their neighbors. But beyond that second tier, the first tier would require, for normal, regular streets are laid out, an extensive set of regulation on wastewater, on road construction. You have a whole section on recreational vehicles. You then go into chapter 6, which is the application process. I think I need to spend some time on that. The application would require the developer initially possibly to meet with the commissioner in that precinct, lay out kind of his plan, But he would not necessarily be required to do that. It's recommended that he do that. But when he comes in and brings his application to the county, that application would need to be vetted immediately. It needs, you should not accept a plat initially without going through a checklist and making sure all of the conditions and requirements of the subdivision regulations are present. When that interview is complete, all of the checklists should have an initial in the approved or received side. There's a second column of places. If there is a blank there or neither is filled out, then you have an incomplete application, and the person should be given a notice of incomplete application, and they would be allowed to go forward, but you don't start the clock. Once you accept the initial plat application, you have a 30-day window to approve that plat, and it's very necessary that you already go ahead and get that to your engineer. If you're going to have an engineer review it, have an engineering agreement that requires them to turn it back to you within 10 days. And you set that matter on the calendar for hearing. There are a chapter on plat requirements, survey requirements, what is required of the plat. Chapter 8 is an application approval procedure, and there is a flow chart in the appendix that lays that out. In chapter 9, we have financial guarantee section that requires the posting of a bond. That bond needs to be at least 100% of the cost of improvements that are being built into that subdivision. That allows the county to inspect those constructions, to review the plans carefully, make sure that the subdivision plat is being built according to the plans. But if you find that there is a departure from those requirements, you have the opportunity to make a proceeding against that bond or cash credit and carry those things out either yourself or through a contract to complete the application, complete the subdivision plat. That bond can be then converted over to a maintenance bond at the end of the construction of the project infrastructure, and it can be extended out 2 years or more. But eventually the roads would stand on their own footing. The county is not obligated by the approval of this plat to accept the roads in the subdivision. That would be your choice. If you choose to, you can accept one or more of the roads. I would urge you to be cautious in that. Subdivisions have a habit of requiring a lot of expense over the year. And as more subdivisions come in, you will find yourself more obligated to take care of it. You then have a section on revisions to the plat, variances to the plat, and finally in chapter 12, what you do to enforce the plat. That's a brief overview. I go into more detail, but on the chapter 1, the introductions, that is an attempt. The legislature is always granting and taking away certain powers. So it's virtually impossible to lay out all of the rules and regulations that come into play, but we've tried to lay out the primary basis for our actions here today. The definition section has been some controversy, but we think we have a fairly well-developed set of regulations that govern the terms used in the subdivision regulation or that are independently self-explanatory. Where subdivision ties into an existing water system, either through a water corporation, a water supply corporation, or a municipality, a certain set of rules apply to those. And then where OSSF or on-site sewage facilities are anticipated, that is a set, they have a different set of regulations, different set of recommended lot sizes. Those are all handled by the TCEQ, or if Van Zandt is qualified to serve in that capacity, they take over and cover lot sizes. The section 1.5 gives you discretionary exemption authority. That if you feel that an application doesn't quite fit into an area that's exempt, you have the authority to grant one-time, one-person use of that development of 10 acres or less. So you've got yourself somewhat covered on either side. I'd like to talk a little bit about the dedication to private use, where the subdivision says, I'm going to build a lot over 10 acres per lot, and I'm not going to dedicate those streets to the public. What does a public dedication look like? All too often we see already developers coming to the court making the blanket statement, this is for private use only. And then you invite vendors, Federal Express, Amazon, propane deliveries, neighbors or visitors, guests. And you look at the list of people who are using those streets, and it looks a whole lot like the public. What do you do in that case? Well, that's a good question, and it's not resolved. So I assume that if the use is such that it cannot be distinguished from a public use, that the county can go to court and sue the developer and seek an injunction to require the developer to alter the nature of their street structure to bring those streets into compliance. Now, where the developer has built substandard roads, narrower roads than your specifications require, that's a tough nut. And so I think we'll just have to see how that plays out. And I would ask you to be on the lookout for any abuses of that type of use. But that is an area that is concerning, and you don't want to let that go too long without deciding, are we going to step in here and take some risk, or are we going to let that go? So just be aware of that. The subdivision regulation has standard provisions over. You have to have evidence that you approached your 911 coordinator, the developer does, to make sure the names in the subdivision, the streets, if any, are properly named, they don't conflict confusingly with other streets. If there is a conflict with any prior regulations, these rules would trump those, they would take precedent over those. If there are any provisions of this statute that are deemed to be unlawful or outside of the court's discretion, the fact that that one section is struck or affected does not necessarily mean the whole subdivision regulation is defeated. This subdivision regulation is intended to take effect on the day you pass it. On water standards, again, I don't want to get too much into the details, but this refers the developer to the Texas Administrative Code, which is where the regulations for OSSFs are contained. And so there are where individual wells or OSSF systems are anticipated. That is where you would go to look for the general authority. Wastewater disposal, they must provide for wastewater disposal methods that are compatible with the TCEQ. They have to satisfy your requirements as well. Where there is a public utility, they will have to certify to and provide to the court evidence that the utility is capable of providing water to this subdivision for roughly the next 30 years. So this is looking out as far as we reasonably can. And water is becoming a major, it's always been an issue, a major issue, but it's really going to become critical. We just have more users than we have suppliers. There's not that much water available anymore. And with conditions, climate change, whatever you want to call it, it's hard to believe we have a lack of water when you fly in the evening and you see the sun reflecting on the water. Seems like flying in last night, it was water everywhere. But usable water, potable water is the question. So as water needs increase, you can apply the rules and regulations that the state has adopted to give you some guidance there. Utility easements have to be anticipated and planned into the development and shown on the plat so that you know where the utility easements can be found. All utilities have to be buried at certain depths if they're going to be subsurface utilities, or above ground utilities have to be known. These regulations themselves do not impose a housing density requirement, because counties directly have no direct authority to do that, but they do have rules through the TCEQ and other rules and regulations that would apply. So those rules would apply to you. Chapter 3 is the minimum standards for roads, and quite a bit of discussion about what your local jurisdiction needs in terms of those standards. And we have incorporated those standards into this regulation. So I'm not going to discuss further that issue. Surface materials that were mentioned and discussed and included in these. In section 4, 3.9, you have setback regulations that are 3.10, I'm sorry. Setback regulations that follow the state law. Generally, any state or federal highway, the setback has to be a minimum of 50 feet. And any designated county roads county maintained roads that are officially promulgated and adopted by the county, and that you have a county roadmap that adopted certain roads for public maintenance. So all of those roads meet that certain setback, building setback. Minimum standards for drainage has also been extensively reviewed and covered. This would require tiny homes, RV parks, campground footage. All of those would need to comply with your drainage requirements. Chapter 5 is minimum standards applicable to tiny homes, recreational vehicle parks, park ground, campground facilities. These have all, again, been reviewed not only by the court, but by the committee. And what we have now is the final product. Generally speaking, it's not to unduly restrict development by people who desire to build those types of facilities, but that public access for emergency vehicles and the like can be reasonably had, that it not be an interference with those that conduct of those activities. There has to be a survey that identifies each individual lot, if you would, that is located in such a development. Some people say, well, I'm going to develop one lot, but I'm going to have several buildings on it. You can do that, but you have to have a segregation of those spaces is a subdivision of land, and so it would fall under your regulation. Chapter 6, the plat application process is as I've somewhat laid out. Generally speaking, there should be a meeting of the commissioner for the court for development in his area to sort of lay out generally what's going to be done. It doesn't have to be a great deal of clarity. It can be hand sketched out, but it does need to be explained to the developer that when he comes to file his formal application, that a survey would be required. The conditions of the subdivision regulation would have to be satisfied, and he'd be prepared to do that. All of that has to be in hand at the inception. Years ago, we would preliminarily accept certain stages of construction, and we would monitor the construction, and only when the project was built would the final plat be approved. We can't do that anymore. We have to approve it within 30 days. So we have to take people at their word, and that's why the development plans have to be particular. So they need to come in and demonstrate that they have the ability to build the plat out as they have described it, and to do that in a timely manner. If they don't start work on it within a 2-year period, or if there is a hiatus in the development, the county has ability to take appropriate steps. I'm not going to go through the different notations and monumentations that are required in chapter 7, but a professional land surveyor or an engineer should prepare those plats. 7.3 requires that they provide additional copies that don't necessarily have to be. I think they will be to scale, but they can be reduced size, but the platting requirements require a certain size. 7.4 is a digital map requirement. This will be provided not only to the county for plating purposes, but also go to the appraisal office if they chose to use it for item purposes. And so the requirement is that it be in a digital format acceptable to the appraisal district. If the surveyor or engineer is incapable, doesn't have the technology, they can provide an affidavit to that effect, and there is an exception. In today's environment, I don't know of anybody that still does not have the ability, so I think most everybody will provide you a digital map. Chapter 8 is the application approval process. It's important that I lay out for you. Your options are to approve the plat if it meets your subdivision regulations. If they meet everything, they get approved. There's no discretion. If there are issues that are not provided, you can do a conditional approval. And that when they provide you the additional material to complete the process, they can get their plat approved. Finally, only in the case where they fail and refuse to find conditions that they can satisfy, can you disapprove a plat. There has to be a material, substantial breach, if you would, of the guidelines. Once you've given them a conditional approval, you don't have the ability to say, we have to have this within 30 days. We have to have it within 60, whatever. You don't set that timeline. That's on the developer. And he can take as much time as he wants, up to 2 years, in my opinion. But once he comes back, you have to grant the final approval within 10 days. Financial guarantees, again, are laid out in chapter 9. They are fairly well defined. They can have several options. They can do letters of credit. They can do a bond. They can do a cash deposit. All of those are guarantees for the construction of the plat and infrastructure. That would include drainage, streets, the like. At the end of their construction, that bond can be converted to a maintenance bond to make sure that they maintain those streets for a minimum of 2 years. And then if they choose to, they can come back to you and seek the admission of at least one or more of the streets in that subdivision for public maintenance. That is at your decision making, your discretion. You're not required to do it. There is no ability of the county to require a homeowners association. I wish there were, but it's encouraged that the homeowners association assume responsibility for ongoing maintenance of the streets. They can assess periodic assessments to cover those costs, but that is the intention. The bond can be extended for good cause exists for periods of time not to exceed 6 months at a time. Chapter 10 covers revisions or cancellations of the plat. We often get requests to combine smaller lots into larger lots and not affect the street infrastructure. Those can be accomplished by the developer without necessarily approval by the commissioner's court. It does require that the consent of the parties involved participate. Otherwise, if they're making changes that change the public interest in the street structure. That would require a plat revision, and there are provisions in the government code that would cover that. Chapter 11 covers variances. Variances are intended to be difficult to obtain. The Commissioner's Court has authority to grant a variance, only the Commissioner's Court. There are special circumstances or conditions that affect the land that make compliance with the regs difficult or impossible to the developer. That it would not be detrimental to overall public health, and that the granting of a variance would not have the effect of negating or causing conflict with the subdivision regulations. Within those parameters, you can consider and act on variances. Chapter 12 is the enforcement section. It has the clear language that no part of a subdivision may be sold or transferred until the plat has been approved. We sometimes see efforts to commence construction of subdivision without coming to the court. You should be aware of those by driving through your county, but some of these pop up pretty quick. And so though selling any lots is really a violation of law, and it's punishable by a misdemeanor prosecution. There are certain disclosures that are required. The first is approval of the plat for filing purposes does not indicate that Van Zandt will assume responsibility for maintaining the roads, street, or other areas dedicated to public use. The legislature struck, it used to say, the statute used to say for public use or for the use of purchasers of the lots. That made it clear that any streets had to meet our regulations. We now have a gap. And so that is the problem with, in my opinion, the legislation. It's not your fault, but it's the state's fault if there are conflicts. Where an OSSF situation is involved, the plat should contain a notation that Van Zandt County makes no representations that adequate sewage facilities will be legally feasible within the subdivision, meaning that if you're not careful and the plat lays out the dimensions of the lot, make sure that the lot boundaries do not include some part of the street. We've attempted to make that clear in the regulations, but sometimes we come down to it and we have a lot that has a minimum of 1 acre, for example. It's going to be served by an OSSF. And yet when we really look at what's usable space, it's the lot within the lot parameters, it's less than a full acre. You can't have a road that encroaches on that acre. So that's the need and the reason for that notation. Also, there's a notation that's required in 14-point type, bolded, that Van Zandt County makes no representation that adequate water suitable for human consumption will be available within the subdivision. This is really merely to protect the county in the event that there is a subdivision built, mostly relying on water wells, and it turns out water wells are inadequate after a period of time. The county is assuming you have no responsibility to provide water in the event that they deplete, the water becomes becomes so scarce that they cannot provide water. That's an extreme situation. I'm sure you would feel somewhat necessary to take steps to address it, but frankly, it's not required. You then have essentially your checklist. You have in Appendix A. In Appendix B, you have your flow chart. In Exhibit C1, you have where the developer is an individual, a certificate that they would have to provide to you at some point in the process. C2 is a certificate by a corporate developer, similar form, but they acknowledge that they're aware of the regulation and agree to follow the regulation. Appendix D is a public utility certificate that basically say that no utility connections can be made until the plat has been approved and that the plat is available for connection at some point in time. A form for the surveyor to fill out, saying he's complied with the rule. A form for the engineer to fill out. A form for on-site sewage facility installers to prepare. A certificate of private road maintenance where they are going to maintain the roads themselves. You want the developer to sign that. Where they may seek approval of the court to adopt the roads, they need to put you on notice of that. You will want to make sure that those roads have been built according to your specifications. I'm going to use this illustration one more time. When you do inspections or spot checks, make sure that you tell the developer, we want to come out and inspect the roads that you have in your subdivision. And they may not have all of them built yet, but they want to show you a particular place where they have. Well, don't just inspect that site. If they have built other roads, don't necessarily test the road that they take you to. We had a case where a developer said, yeah, I'm ready for inspection. The inspector went out and they took them to a particular location. They did the core sample, they did the test, everything looked good. About a year, maybe it was not quite 2 years later, the roads in the rest of the subdivision, the roads right there where they tested were still good. But the roads elsewhere were already showing signs of wear and tear. So I'm not saying that developers are unscrupulous, but some try to cut corners. And so be aware. Once they've met everything, there is a form that if you choose, the county can use that. There is a form for construction within your right of way under Exhibit K. There is a summary of road standards in subdivision regulation. And it's generally just a general summary of road requirements. There are forms for revisions of the plat. There's a lien holder acknowledgement of the plat requirements. And in Exhibit P, there is your fee structure. Finally, Exhibit Q is a form for a letter of credit. Does the court have any questions?
Yes, sir, I got a few. So, one of the changes that was made to these by the legislature too, is that previously it was 5-acre lots in order to be exempt, and that's 10-acre lots, correct?
Well, there's always been an exception for 10-acre lots over and above 10 acres. When we passed our ordinance, what, 4 years ago?
21, yes.
The court here wanted to adopt a 5-year. So that statute does call for a 5-acre lot. Could be exempt, but with the change to the statute, that did not seem prudent, given the fact that the 10+ acres could open a can of worms. Didn't want to open the can wider, but we did put in the discretionary exemption that you could apply to lots that are 10 acres or less. So you still have the ability, but it's not necessarily law.
Okay. You say that approval must occur within 30 days. When does that 30-day period begin? Is it when the commissioner receives the plat?
It begins when the reviewer here at the county checks off and is satisfied all of the requirements in Appendix A. So you go through that checklist that is at page 50. When that list has been satisfied, you have a complete application. In other words, when there is a reviewer's acknowledgement that the subdivision plat application is complete, that starts your 30 days. Until they can hand the developer a photocopy of a development plan that is fully executed, all blanks filled in, it's not considered to be a complete application. So this 30 days does not begin until that point.
Okay.
So it don't start when they file the clerk's office. It starts when completed applications are there.
Right.
So if they file an incomplete one, it don't matter. They just file an incomplete application.
They should file that with whomever is the designated reviewer, and that can be the commissioner, or it can be someone else that reviews the plats. It's important that that person know what's in the regulation. They have to read the regulation, be careful that everything there. But they'll follow the checklist, and if they can say, where is your plat that shows the acreage of every lot in the subdivision? Now, there can be a subdivision that has 50 lots, and 10 of the lots are over 10 acres, but the rest are under 10 acres. That's not one that is subject to exemption, because you got to mix. All of the lots have to be over 10 acres to meet the exemption. So unless they can show you that clearly and unambiguously, again, the roads don't take any of the lot into the road definition. So it's very important that you review those plats carefully. But if they have your reviewer's initials in each of the blanks, and it's all complete, that is a complete application. Anything less than that is not. When you have an incomplete, you ought to advise the developer in writing, give them a form letter that says, we've received an incomplete application. Attached to this is the review sheet. You need everything that has an unchecked check mark space needs to be completed. He can take that, and you don't have an complete application. When he brings it back, you check it again. He may still have some blanks. Give him the same letter. Now, if it's a conditional approval, it's something that they have informed the court. Here's our intention on this. We're waiting for a water availability study. Okay, we're gonna provide that later. EdCog is gonna take care of that at a later date. When they have that certificate in hand, then they can come back to you, you approve the plat. But it's not something that you have to approve without having a complete application or all conditions satisfied.
Okay. Any questions about that? All right, next question is, how will the new guidelines affect currently approved subdivisions and ones that are currently in process?
Anything that's been approved or is in process at this particular time is under your old rules. And so they're covered by the old rules.
Okay,
If once you adopt these rules, then that grace period lapses, but they are not affected. They are approved, or if they've been approved, they stay approved. If they're pending approval, you would consider them under the old rules. Anything filed after today would have to meet your new rules.
okay. Explain again, when someone says I don't have to file subdivision because I'm just using one lot, but like they're using it for RVs or things.
The RV section, section 5, I believe, covers that. If they have no more, I think it's 4 lots, they may be exempt. In that section,
26, page 26.
yeah. Looking for the number. Kind of went back and forth on whether that should be 4 or fewer or 4 or more. I think it's 4, but I don't find the 4 mentioned. You can have, subdivision, or you can have a tract of land that you have minimum number of campers that your family pulls in for family reunions and the like, not violating statute. But if you go over a reasonable number, you then need to comply with the statute. I'm sure there's something in here that tells us that, but right offhand,
52C.
5, 2, 6, 3 additional recreational vehicles for tiny homes, so it's 3.
That'll be a total of 4, so, okay.
Right.
All right, any other questions about the one lot fits all? Mr. Beckham?
I mean, just a correction on this, it's no more than 3, so.
Okay, all right,
So it's a.
thank you. All right, next item, bond requirements. Is this new to these guidelines?
No,
It's not, okay. So, and what is the extent of the coverage of a bond requirement? What is the bond?
it's intended to make sure that the infrastructure, the improvements to the property are completed as per the plan. The bond has the engineer, or the surveyor has to certify as to what the anticipated cost of the improvements. Those are the streets, the drainage, setbacks, utility easements, all of the improvements. those have to be stated, the value has to be stated, and the bond amount should be at least 100% of that amount. The court could go upwards from that, some counties at 125%, but at least 100%. And then the bond can be used by the county to either undertake to do the work with your own labor and equipment, or you can contract it out to a subcontractor who would do the work within those parameters. That answer your question?
Yes, sir. Yeah. So, and, we were talking about, I've seen this. Where someone takes, say, 20 acres and divides it up into 5-acre lots. All of them have frontage on a county road, so there's no, do they still need to?
If a road encompasses all four sides, arguably, but you know, your exception for second tiers does not allow development beyond 4 lots, I believe. Let me make sure that.
That's second tier. What section is that in? At the very beginning, correct?
Yes, sir, it's at
Actually,
one
probably
point
section.
four. 1.4. Sorry, it's 1.6. Is limited to 4 lots. So if all 4 lots front on a county road or a state highway, they could build that with a second tier. Or if it's a strip of land, they could build that, but they could not exceed 4 separate lots.
What happens when it goes to 5 lots?
Then you have to follow the regulations.
For tier 1.
Okay.
You do have the discretionary exemption that you could grant for 5 lots, but that would be up to the court to take that up individually.
So if it qualifies for a tier 2, except they do more than 4 lots, it becomes a tier 1.
Yes, sir. Now, again, they could apply for the discretionary exemption in 1.5. But that would be a decision to be made by the full commissioners court. The subdivision regs have a minimum frontage requirement of 60 foot. And so flag lots are conceptually possible, but they have the entrance to that lot must be at least 60 feet.
Would you define what a flag lot is for me? I'm sorry. I'm sure everybody in here knows, but I don't, so.
A flag lot is generally described as a lot, and if you look at it on a plat, it looks,
Oh, okay. Commissioner Pearson just
yeah.
drew me a picture. I do well with pictures.
And a flag lot is defined in the definitions with at least a 65-foot wide entrance. Now, the reason flag lots are not favored is that there have been developers who would come in and grant a 5-foot lot and maybe put several lots together and assume that all 5 of those individuals would share that larger entrance. But they would convey to the lot only the smaller part. And so you have these odd structures where you have a flagpole and a lot. And history has proven that people would get into disturbances and squabbles, and they will fight over that and argue, you're encroaching on my driveway. And so we have tried to eliminate flag lots largely, but it is still possible. But look at your plat application very carefully when that, if somebody's going to try to do a flag lot, in my opinion, they're trying to cut corners, and so be cautious about that.
Did you say the flag lot goes out to 65? 65.
I have it at 60 feet. That's the minimum. That would include the total width of the county right of way.
There's the definition right there.
But if somebody wanted to put 2 adjacent flag lots, they're gonna have to have 120-foot wide stretch. 60
Yeah.
for this lot, 60 for that lot.
Yes.
Okay. That's all the questions I have. So anybody else have questions to ask? Mr. Becker.
Thank you, Judge. You know, we're back in this process because, my understanding is that there was confusion from developers, public, and of course, on how to enforce our previous, regulations. And I think that the intention here was to make something that's more clear and provided more clarity for everyone that's using this. And, you know, we had a couple of revisions this spring, and I'm not speaking for the entire committee right now, just for myself. Feedback that we gave was, you know, here's some things we'd like to see so that these are more clear and easier to read. Those things did not happen. There are currently errors in the document that's presented, things that conflict within the document. The reason I joined the committee in the first place, the very first draft of this thing 4 years ago, was frankly, Mr. Bass, a mess. When you said that things today here were carefully vetted, you know, what I see in this draft again is copy and paste errors from other regulations that were piled together for this one. The flow chart, for example, is an earlier draft that I prepared as part of the committee that refers to prior paragraphs. If the idea is that this draft of subdivision regulations will provide more clarity for everyone using them, I don't think we've achieved that goal, quite frankly. But I understand the Commissioner's Court wants to move forward. If y'all think that this is more clear than what we had before, then y'all are the ones unfortunate, not me. But I mean, just here today, we've heard from Mr. Bass that actually 10-acre lots, if there's a private road, that's not really a private road, that's a public road, so this is subdivision. We heard today, if they're building multiple structures on a lot, then that's a subdivision. And I don't think those are what your intentions were. So if the goal is to make something that will reduce headaches for the Commissioner's Court, I don't think that this draft is achieved.
Well, I appreciate that, those comments and the intent. My understanding intent is to get our, this revision and what you said is right in our previous meetings, but the main intent is to get our subdivision guidelines current with what the legislature changes were made in 22,
So
23.
The one change that was made, that is in compliance with that, was the expansion of the exemption. As Mr. Bass said earlier, the exemption said, this will only work if the developer does not lay out any part of the tract for a road for the public or for the private use of the owners. And while that language is here, what we're hearing is that, that regardless of what the legislature said, that actually there's no such thing as a private road, because we've got delivery drivers that are using it. So the 10-acre, 5-acre exemption, the committee and the board talked about that previously, and it seemed to be that the policy decision of the court was we had a 5-acre exemption, and we want to increase that to 10 acres. What the exemption that the legislature provides is, it is a minimum. So previously, in the first iteration of this, the commissioners court adopted a 5-acre minimum, which is completely legal. I mean, that was, you can always have exemptions over what the legislature mandates, but the legislature mandated 4. And so the 5-acre, 10-acre lot size is wholly a matter of policy preference by the court. And, from our previous meetings, it seemed like y'all were inclined to go 10, and that's fine. But the only thing that is mandated by that change is changing the language on public roads and private roads as part of the subdivision. And again, while that language is reflected in this draft, that is not what we've heard.
I'm just trying to point out. All it says in the statutes is the developer's intent to have private roads. And if that intent is just an expression. But the real world use of that street infrastructure is indistinguishable from from public use. There could be litigation to challenge the developer's intent. I'm not saying, I think as long as they put a gate and say all of the streets in the subdivision are private, and people have to go through a security gate to get in, and they can do it with a passcode. I think probably that would suffice to show to the public that the public is not invited in, and only those who have our passcode. I mean, that's probably okay, but my fear is that there will be no difference between an under 10 or an over 10. The streets will be there, hopefully built to a high standard. But there could be possible litigation. That's my point.
Okay, the litigation though would be between the developer and the lot owners, correct? It wouldn't be with the county.
Well, the county could have a part in that, I think, if it was found that, there's really no distinction between the public and private, and anybody can use those streets. That's generally welcoming the public to use the streets.
But there's still no obligation in the
No
county.
obligation.
Okay. Any more comments? I believe we've been working on this 2 years or since the last one. And while it's not perfect, I
I've
think,
made the changes that, I was asked to make. I do appreciate Mr. Beckman's contributions. But,
we will, start working on the suggested revisions for the next one, if commissioners decide to go ahead and approve this, this version. In that regard. Any other comments before we close the public hearing? No. All right, so I announce we will close the public hearing at it's 10:08. We'll go back into our regular meeting. Item number 5, discuss, consider, and approve adopting Van Zandt County subdivision regulations and adopting the takings impact assessment. Is there a motion to approve adopting the subdivision regulations and adopting the takings impact assessment?
Motion made.
Commissioner Pratt makes the motion. Is there a second? Could you speak up? I couldn't get it. Second by Keith Pearson. Any further discussion? All those in favor say aye. Opposed, like sign. Motion passes. Item number 6, discuss, consider, approve 1 6-month lease agreement and payment concerning belly dump trailers from Brazos Trailers for precinct 3.
Yes, sir, Judge. Get caught up on this.
Damage from the storms.
Mr. Phillips. We're gonna get one about it done. The rest of the year.
Okay, for 6 months.
I make that motion, authorize you and myself to sign the lease.
Okay,
Second.
motion made and seconded. Any further discussion? All those in favor say aye. Opposed, like sign. Motion passes. Item number 7, discuss and consider approval of fiscal year 2024 line item transfers. One transfer, I believe, is yours
Yes, sir.
for $1,000 to cover tires.
Yes.
Okay, so is there a motion?
Someone Pierce.
Is there a second? Motion and a second by Commissioner Pratt. All those in favor say aye. Opposed, like sign. Is there a motion to adjourn?
So made.
Second.
All right, motion made by Commissioner Pratt, seconded by Commissioner Pearson. All those in favor say aye. We are adjourned. Thank you all, ladies and gentlemen. Yeah. No. Hold on.
Oh, okay.
All right, I need to go modify those